Hello everyone, I'm Eesha Sharma, intern at ubAdvocate, and today I'm going to be talking about the relationship between international law and municipal law. Municipal laws are the laws of a sovereign state which regulates the relationship between the citizens and the government bodies. These laws are specific to a country owing to many factors and internal matters of a nation. International law, on the other hand, is the body of rules that has legal obligation on the states. It governs the interaction between states and between international organizations and the states. These laws govern the conduct of trade, diplomatic relations, human rights, and works to avoid wars between the member states. The main point of difference between international law and municipal law is that international law is derived from the collective will of the states, whereas municipal law is derived from the will of the sovereign. International law deals with the member states and international organizations, whereas municipal law deals with the individuals within a particular state. International law deals with the relationship between the states and with the international organizations, whereas municipal law deals with the relationship between citizens of a country and their government. There are four theories which deal with the relationship between municipal law and international law. The first theory is monist theory, which is of the opinion that there is only one legal system, which is known as the domestic legal order. The scholars of this theory deny the existence of international law as a separate body of law. The scholars are of the opinion that there is a single body of law which is capable to serve the needs of both the nations and the individuals of a nation in one way or the other, making two separate systems of law similar to each other. The next theory is Dualist Theory, and the scholars of this theory believe that there is two bodies of law which are different from each other in terms of their source, subject and subject matter they deal with. They are also of the opinion that there is no question of which body of law is supreme from the other, as there is no common ground between them to compare. The scholars are also of the opinion that international law only has the authority over the different nations, and the state are free to have their own rules and regulations on their internal level. The next theory is transformation and specific adoption theory. And this theory is based on the concept that international law itself cannot claim that they should be a part of the municipal law of a nation. They can be applied only if the municipal law is of the opinion that a particular provision of the international law can go through a process of transformation, and if they can adopt a particular provision into their own municipal law. The next theory is Delegation Theory, which is of the opinion that each state has the authority to decide for itself as to what international provisions should be applicable and implemented into their own municipal laws. They are also of the opinion that state has the power to determine that in what manner a particular international provision should become a part of the municipal law. Now let's talk about the relationship between international law and municipal law in India. The Indian Constitution has given consideration to international laws and treaties. It states that the country should promote international peace and harmony with other nations and should foster respect for other nations and international laws. It also gives Parliament the power to make certain laws as well as to repeal the laws which are inconsistent with the provisions of the existing laws. In India, the dualist theory is observed as international laws are a part of the municipal laws, however, they can only be adopted if they are not inconsistent with any of the present legislative enactments of the country. The international laws do not become a part of our country automatically, rather they come into force only after the Parliament makes them into a statute. In the case of Shri Krishna Sharma versus the State of West Bengal, the Calcutta High Court observed that if there is a conflict between the Indian Statutes and the principle of international law, then the Indian courts will first have to give their preference to the Indian Statutes and the Indian laws which are being enacted by their own country, and then they can look after the international principles. The fact that the Indian courts follow the dualist approach, as the treaties become the part of the land only after they are being enacted by the state legislature or the parliament. The international conventions and norms are duly considered by the courts in absence of a domestic law in that matter. Thank you.